Good afternoon, everyone. My name is Kathy Carlett. I am the mayor of the city of Peoria, and I am pleased to be here with you today for the concurrent session, Trending TPT Issues, Digital Goods, the Wayfair Decision. Before we begin, I have a few housekeeping items to announce. The first is handouts for all sessions will be located on the League's website and on the League's conference mobile app. In addition, biographies for all conference speakers are included in the conference app. Before we begin, I'd like to remind everyone to quiet your cell phone, and also I would like to let you know that participants know that this session may be eligible for CLE credits for attorneys, which it is. Please sign the CLE sheet in the back of the room, on the side door. It's right out that side door. And there needs to be at least 5 attorneys in attendance to sign the sheet to receive CLE credit. So there are the rules for that. Okay, so let's get started. Our topic this afternoon again is Trending TPT Issues, Digital Goods, the Wayfair Decision. Over the next hour, you will hear a brief history of digital goods bill that died last session, including perspectives on what the future holds for future digital goods legislation. In addition, this afternoon we will examine the Supreme Court's recent Wayfair decision, a decision that overturned 50 years of physical presence being the standard for TPT nexus, the potential impact this will have on municipal revenue, how economic presence will work in day-to-day operations, and lastly, how cities and towns can adapt to the new nexus landscape. Our speakers today include 2 familiar faces from the League of Arizona Cities and Towns, Tom Belshey, Deputy Director, and Lee Grafstrom, excuse me for that, just wanted to say it twice, Tax Policy Analyst. So Tom and Lee, I will now turn it over to you.
One of our fine council members from the city of Sierra Vista told me to try to be more exciting because this is after the session, after lunch, and I wish her the best of luck. This is a difficult topic to talk about. It takes a little bit of concentration. It's not something that's always easy to understand. But Lee and I are going to do our best to try to give you some ideas about what we discussed during the legislative session about TPT issues, specifically digital goods, and then the recent Wayfair case. I'm going to take the digital goods legislation, and Lee's going to cover the Wayfair case. First of all, what we want to discuss is what is meant by digital goods. What does that cover? There's a lot of misunderstanding about that term, so we're going to take a little bit of time talking about that. We're going to talk about the legislative history from this year on it, and then we're going to talk about what we think is coming up next for that particular issue. And then, as we mentioned, Lee's going to cover Nexus, what that means, why it's important to taxation, especially when it comes to online sales. We're going to talk about what the Wayfair decision was all about and what it actually said. There's been some things said about it already that we don't think are quite true, so we're going to give our perspective on that. And then what does it mean in Arizona? And one of the things that, because this is a very data-heavy kind of explanation-heavy kind of presentation, we're hoping to hold the questions to the end. We're going to have 15 minutes at the end for questions. We're hoping to get through most of those questions and have them answered for you before we get to the end, but we will give 15 minutes for that. We have to be out of here on the dot at 3:45, we've been told by the staff. So with all that being said, we're going to go ahead and jump into it. Digital goods are delivery of products over the internet. So when you think about anything that used to be a good that you could buy in a store and that you can now purchase over the internet, that's a digital good. So there's hundreds of examples of that. But you might think of streaming music, you might think of DVDs, CDs, there's all kinds of different examples of what we're talking about, but basically what we're talking about is software. We're talking about zeros and ones, and whether they come on a CD or whether you get them over the internet, they're basically the same product. What we're talking about and the difference is delivery systems. And so that's the crux of the whole thing when we talk about digital goods is they're simply the same products, but they're being delivered in a different manner. It doesn't make them magic. It doesn't change the product. It just means they're being delivered to you differently. Anything that's delivered in a file or stream is pre-written software, and so that's the things that we talk about. That's delivered to your device, and that's what a digital good is. So how are those things taxable? Okay, this is what we call rental of tangible personal property, or TPP. Okay, so these are all the things that can be seen, weighed, measured, felt, or touched, or is in any other manner perceptible to the senses. So as we get into this a little bit later and we talk about the bill that we fought this year, one of the things we kept hearing over and over again is because these things were delivered in a different manner, even though you could get it in a CD at Best Buy, because it was delivered digitally, it made the product different. All of this is saying is that no, it's subject to taxation because it still can be felt or sensed or is perceptible to the senses. You can still see that same movie on television regardless of whether you're streaming it or you've got a DVD in your machine. And just because the fact that you can hold on to the DVD doesn't really make any difference at all as far as taxation is concerned. We believe that TPP has been in place for a long time, and simply because new technology comes along, that doesn't change the way that these things are taxed. They've been taxed forever, and we can believe that they will continue to be taxed. 1943, okay, there was a court case that kind of set the precedent on this, and it was a song played on the jukebox is TPP. You put a nickel in, you don't get to keep that song. You feel it, you can perceive it, your senses hear the music, it's coming through, you've rented that song for that amount of time that you put that quarter into the jukebox or that nickel into the jukebox at that time. So those are really important things to keep in mind because people get caught up in the fact that, well, you know, this stuff is traveling through the cloud. The cloud is a platform. The cloud is software. The cloud is not actually the clouds. This stuff is not traveling through space. Okay, the internet is an actual. People laugh. Okay, I hear some snickers out there right now, but this is the kind of testimony that we were hearing during our task force. And so we want to make sure that we're very clear about that. The cloud is simply an idea. This is where items are stored so that you can have access to them. All right. So I was invited to participate on an ad hoc joint committee on the tax treatment of digital goods and services. And what we were told is that the idea was to update the statutory definitions related to these types of products, which we thought was a good idea. In fact, one of the things that we told the committee was the definitions that exist in our Model City Tax Code for cities and towns are actually better than those that are in state statute. And we thought that if they adopted those same definitions in state statute, that would go a long way to making those definitions better. They wanted to determine what exempt digital goods and services existed, what was taxable, provide a uniform state and local tax treatment, and then clarify sourcing and nexus. The thing about it is that we never really got to clarifying nexus or sourcing. We spent a lot of time talking about things that the ultimate fight that happened in this bill is over one thing. All of the digital goods that were being considered, that were being talked about in the bill, we considered to be taxable, every single one of them under TPP. And so what happened was, as we clarified the definitions in state statute, what happened was we created 8 new exemptions in the state tax code. The claim was that because those things were not currently in state statute, that they couldn't be taxed, that there was no authority to tax those things. Well, we beg to differ because we had people who were actually paying. We have tax returns that show that people were paying that tax and understood that they had to pay that tax. And so it was clearly the language was creating these exemptions. So we went back and took a look at, okay, each of those categories of tax. And we got tax returns from cities and towns, and they put the information together for us and sent it over to us, and we calculated what the loss would be to cities and towns, and then having the loss to cities and towns, we could estimate also the state loss and the loss to Prop 301 monies. $121 million to the state, $45 million to local taxes, and $14.5 million to Prop 301. So we spent a lot of time going back and forth about things like streaming services, things like what was provided through things like Netflix and Spotify, and we talked about a lot of different companies. And I don't know how many of you use these services, but if you use any of those services, you'll notice when you rent something on Netflix or when you pay your monthly bill, there's a tax on it. Okay, that is a state and local tax being charged on that. Okay, it's clearly things that were taxable, and that's why there was such a large amount of money that was associated with it. We were expected along the way, because we have the same tax returns now as the state, people report on one tax form, and they report both state taxes and local taxes. That was part of the tax reform that took place a number of years ago. We, having those tax returns like the state does, we were very surprised the state told us that they couldn't provide a number. And so that's why we went ahead and calculated a number based on the fact that we know what the percentage of state tax is and we know what the percentage of city tax is. And so we were able to estimate the impact. And so we provided that. It caused a little bit of a stir. There was a lot of questioning. The JLBC took a look at our methodology. They had no problem with our methodology. And they provided that information in one of their reports to the legislature. So, what's going to happen next? We expect the digital goods bill to come back. We expect that there will be talk about it again. Our hope is that we'll continue to get the kind of help that we receive from cities and towns in the beginning, and that is that your folks will develop information that they have available to them through the Department of Revenue and the reports they send to you, that will be able to develop even better, clear numbers on the different types of things that we're talking about, the 8 different exemptions. Because, again, this is a significant, last year with a budget that was so close that there wasn't any kind of room for error, $120 million to the state was a big deal. Obviously, $45 million to the cities and towns is a big deal as well. And so we consider that important, and we think that it's important for people to know that these things are taxable, that they have been taxable, and if we're going to exempt them, that is not our call as cities and towns. We think that we should continue to receive the revenues, and we think they should continue to be taxed. But if we're not going to tax them, then we should say so. We should say that we're creating an exemption. We shouldn't say that they shouldn't have ever been taxed. One of the things that we found that was very important is that this has to do also with the fair and equal treatment of all taxpayers. Who is competing with this type of online sales? Well, it's the Best Buys of the world. It's I heard that the Blockbuster rental has one more store, and it's about to go under. Now, I'm not saying that we should revive Blockbuster or anything of that nature, but anybody who has to pay taxes should all be on an equal footing. And simply because people receive something in a different manner, a different method of delivery, doesn't mean that they should be able to avoid tax. We also believe that sourcing and nexus are important. What we mean by that is when you pay the tax, and we know where that tax is being paid or where that item is being bought, that tax should end up with that state and also with the city or town where that taxes or that purchase is being made. And so this is what I want to turn over to my colleague Lee Grafstrom. He's going to talk about the Wayfair decision, and he's going to talk about sourcing and nexus and the importance of those things.
Okay, thanks for putting us all down like that, Tom. Appreciate it. Come on now, kids. We're talking about taxes. How can you not be having a good time right now? I know I'm thrilled. So, yeah, I know I'm weird, but so what? Let's, come on, work with me. So one of the big things that came up in the discussion when we were talking about digital goods, and one of the issues that we brought forward and actually managed to get a little traction with, was the fact that as we were attempting to put these new exemptions and lock them into the statute, there was a critical court case going on at the Supreme Court, and that was South Dakota versus Wayfair et al. The et al. Being Overstock.com and Newegg. Those three online retailers sued the state of South Dakota over a change in law that South Dakota made a couple of years back that was intentionally created to challenge the existing standard of physical presence being the requirement, the law of the land. In 1967, a company called National Bellis Hess, a catalog company, was taken to court by Illinois, trying to get some sales tax from them, and that was where the beginning of physical presence as a rule was established in the National Bellis Hess case. In 1992, Quill Corporation, an office supply company, again another mail order sort of company, where my best friend for my entire life worked at the time, took North Dakota to court, and my friend was quite happy when North Dakota lost that case. They upheld National Bellis Hess at the time. They upheld the standard of physical presence in a state in order to impose sales tax. And I was very upset. But even then, in the Quill court case, the court then even said the legislature, the Congress, should really step in and change this rule, or technology will change this rule for you. So what Quill said, physical presence is required in any state in order for that state to impose its taxes. And what physical presence means, or meant, I guess, is you've got a store, you've got a warehouse, some sort of a location, you're holding inventory there, your salesmen visit at least 3 times a year, you deliver things by your own vehicle, you have agents who do installation and repair and those sorts of things, do servicing for you. If you have those sorts of attachments to a specific state, then that's enough for that state to require you to collect the tax for them. Okay? Now, at the same time, and we'll cover this a little bit more later, that only applies to sales tax. With other types of taxes, there's a whole different set of court cases, and the one we'll talk about will be Complete Auto Transit versus Brady, which set up a concept of substantial nexus as opposed to physical nexus. So what South Dakota passed a couple of years back was a rule called economic presence as opposed to physical presence. And the basics of it, when you get down to the nuts and bolts, anybody who's making at least $100,000 in sales in the state of South Dakota, or has at least 200 transactions with people in the state of South Dakota, according to the new law in that state, you had enough physical presence, enough economic presence to require payment of the tax. You were maintaining a market there, you were establishing a market there, you were taking advantage of their court systems to enforce your contracts, all of these things. You clearly had enough interaction with the state, even though you didn't have a pure physical presence, you had so many other things happening that clearly the state was providing you services and therefore you could be subjected to tax. That's what Wayfair, Overstock, and Newegg were fighting. They were each assessed, and the court case moved up to the Supreme Court. So the court case was, the arguments were held in March, I believe it was, April, and the decision came down in June. So as we were discussing the digital goods bill, we were trying to tell legislators that, there's this case out there that's going to drastically change, we believe, the landscape of sales tax, particularly here in Arizona, but across the whole country. So before we go and enshrine these new exemptions, whether you agree with them that they should be there or not be there, shouldn't we at least wait and let the Supreme Court come up with its own determination as to what's going to happen? So the decision in South Dakota versus Wayfair says one thing and really one thing only. It says that the physical presence rule of Quill was unsound and incorrect, and therefore Quill and National Bellis Hess are hereby overturned. Stare decisis does not control. There is no physical presence requirement to impose sales tax, or in our case, TPT. So here's where and the question of physical presence was trying to determine what is the Commerce Clause, the Silent Commerce Clause, and how does it apply in sales tax case. Essentially, that says you cannot interfere with interstate commerce at the state level. So as I said, there was the Quill decision on the sales tax side. On all other types of tax, the controlling case was Complete Auto Transit v. Brady, which had 4 steps to it. And the difference here is instead of physical presence, it had substantial presence, substantial nexus. Substantial nexus means you are actively maintaining or growing a market in a particular state. You are actually doing something within that state. You don't have to physically be there, but if you are accessing the market, if you are accessing those customers in a substantial way, then you can be held liable for the tax. It also has to be fairly apportioned, which is a method of how you charge taxes locally and across the state. The most important piece is it cannot discriminate against interstate commerce. So in other words, the things that are taxed locally and taxed by a remote seller, an out-of-state otherwise located seller, they have to be taxed in exactly the same way. You can't set up a system where an out-of-state seller who's accessing the local pays an extra higher percentage or has to pay in a different method or manner than what the local folk do. And finally, it has to be fairly related to the services provided by the state. And there again, the major item that's provided by the state is access to the courts, the ability to enforce contracts, place liens, do all of those fun things to try to collect your money, chase people with bad checks, et cetera, et cetera. Not to mention all of the delivery availability of highways, roads, and streets, et cetera, et cetera. So the key pieces to this is, the 2 key pieces to this, are you are maintaining a market in that state, and you are not being discriminated against simply by being an out-of-state company. Now, there's a lot of other stuff that's in the decision. They talk about South Dakota was a member of Streamline. They sort of toss that in there. There's 22 or 23 states that are a member of Streamline. None of them are very big. Streamline's never really caught on. Streamline is really just a set of definitions that you either adopt as being taxable or not taxable. The likelihood of Arizona, I'll editorialize for a minute, the likelihood of Arizona adopting Streamline anytime in the near future, I'm going to guess is going to be relatively slim, because you have to adopt that set of definitions and decide if that's taxable or not taxable. So that means everything that we have right now enshrined, thanks to Prop 108, as an exemption, has to somehow be squeezed into the new set of definitions or removed somehow, and someone will have to vote for that. So the likelihood of all of that somehow magically coming together is pretty slim. The rest of what's in there talks about it wasn't an undue burden on interstate commerce because it set that $100,000 minimum limit, so small businesses weren't going to be impacted overly. 200 transactions is a lot of transactions. When I know when Lee's dream catchers are online on Etsy, it's hard for me to get 200 sales in any one state, so I'll never get to the $100,000 mark, or I wouldn't be here. Those were things that were important. And if you were involved at all in the resolutions process earlier in the week, the league does have a resolution related to this topic, and that is that we know that legislation is coming eventually, and we hope to shape that in the direction of some clear dollar limit as a minimum threshold, some clear number of transactions as a minimum threshold. No retroactivity. It has to start going forward so people aren't penalized for something that wasn't in the books before. The little things like that. And we are moving to make the retail section of the Model C tax code match the state version of retail to the extent necessary to deal with remote sellers. So what does the decision mean in Arizona? So first of all, when you strip away that physical presence requirement, that happened immediately that day. That day, physical presence was no longer the basis for requiring someone to pay tax. It was now falling back on whatever the rest of your laws said. At that time, there were many states that had already copied something along the lines of South Dakota and had created their own thresholds and their own set of rules. There were other states that had marketing presence was a rule, a little more esoteric, a little more judgmental. There was click-through nexus, there's affiliate nexus, there's a variety of methods of coming up with who has quote-unquote economic presence. We would be supportive of clear dollar thresholds, clear number of transactions. But all of that happened immediately effective the day of that decision. Since then, many, many states, including all of those that had those set of rules in place already, have announced that they'll begin enforcing it. October 1st is the most common date I keep seeing. Every day I get another one or two states that have just announced that they will begin enforcing economic presence as of whatever day. So we've talked to the Department of Revenue about that. Another interesting thing that happened, when you look at the universe of retailers, Amazon, as everyone can guess, is the 800-pound gorilla here. They are the big dog in this fight. They have been paying taxes in Arizona and really across the country on sales made by Amazon for some time now. So we've been getting their revenue with no trouble whatsoever. There's another group of folks who sell through Amazon. Those are their third-party sellers. Typically, when you bought something from a third-party seller, there was never any tax on it because they didn't bother to pass it through for them. Amazon took no position and let them decide whether or not they needed to be licensed or not, and the vast majority of them were not. So the Wayfair decision came out on the 21st of June. The following Monday, Amazon announced to the world, all of their third-party sellers, you may now go and get licensed and registered with every state where you have at least a minimum number of sales, or you're no longer going to be sold through Amazon. So suddenly, the Department of Revenue starts getting all of these new licenses and can't figure out where the heck they're coming from. And I'm like, are you not reading the same things I'm reading? It's from Amazon. That's where they're all coming from. They're coming out of the woodwork. We had a question the other day from one of the mayors, who will be doing the enforcement on that third-party seller through Amazon? And I said, that'll be Amazon. That's way better than the cities can do, or the 10 or 14 auditors that the state has. Amazon will take you and kick you off if you're not in line with whatever their rules are. And being so big, they have a lot of sway in that group. So that's happening. As I said, we talked to DOR about all of these things, and at the Department of Revenue, their position at the moment, at least, is they're doing a very good job of collecting information. They've put together a good collection of the state laws for every single state that has a sales tax and what exactly it says. Essentially trying to get a sort of looking for a best practice, apparently. They're looking at how they have been treating it and how they intend to treat it going forward, remote sellers. And also, I don't know if they're doing it, but I'm doing it. I'm collecting the effective dates for all of these different states. What we're not expecting to see is any activity from the Department of Revenue in terms of enforcement or compliance or really probably even announcement to the public because they anticipate legislation coming in January. So rather than step on the toes or get out ahead of that, ahead of the truck, they're going to wait and let the legislature take care of that. So for right now, you are probably going to be seeing additional revenues coming in because all of those third-party Amazon people have started to collect and pay for you. Other taxpayers are also coming across and signing on. The biggest issue that we have to deal with in the coming session, I am sure, and the thing that you need to keep in mind relative to the change in Wayfair and how this affects remote sellers, and suddenly the concern is that there's this windfall myth out there that suddenly there's hundreds of millions of dollars of quote-unquote new revenue that will be showing up out of nowhere. The reality is, and forgive me, but the most recent information I've got to look at is from 2014, from an internet retailer survey that they do for themselves, an industry survey of the top 20 taxpayer or top 20 retailers on the internet. There was only one, number 17, Wayfair, that was not already licensed and paying tax in every state. Just one. The other two folks who were in this lawsuit, Overstock came in at around 20, I think it was 28, and Newegg was 34. And those were the actual top three who were not already paying tax everywhere they made any sales. So Amazon obviously number one, but they've got a chunk of their business that were those third-party folks. Then you drop down to number 17 and 28 and 34. In fact, out of the top 100 on that list, 83 of them stated that they were already collecting tax in every state, in every jurisdiction across the country. So there's only a small, relatively small group of companies out there that are left to be picked up, that are left to create quote-unquote new revenue. So there's a very bad study from decades old from the University of Tennessee that says the states are losing something like $13 or $20 billion a year. It was bad then, and then they extrapolated from there, and it got even worse. So those numbers are way out of whack. They're not at all realistic. There's nothing even close to that amount in my professional estimation out there. It just can't possibly be. With that, we actually have a little extra minutes, so let's go ahead and start taking hold on, let me get to this part. There you go. So if you yeah. So go, I'd be happy to take questions now.
So is it sales tax to state and local sales taxes?
Correct. So
Has that always been the case with Amazon, or would it be
the situation with Amazon, I'm going to defer to Sean. No, I'm kidding, Sean. I'm not going to throw you under that bus. Oh, okay. The question was, has this always applied with regard to Amazon, that they were collecting the state and the local tax across the entire state? That is a difficult question to answer. When Amazon originally started reporting, they started reporting under an agreement with the Department of Revenue. That agreement with the Department of Revenue was confidential and secret. We believe what it meant was that if it was sold out of the Phoenix warehouse, then Phoenix would get the tax for local tax. If it was sold out of the Goodyear warehouse, then Goodyear would get the tax. And if it was sold coming in from any warehouse outside the state, there would only be state use tax unless it was delivered to Phoenix or Goodyear. Ish. They weren't paying everywhere is what it came down to. I don't know the particulars because, again, it's confidential and Sean couldn't possibly tell us, or you have to kill us all. So, no. what's happening now, or what we anticipate you're going to see happening here very shortly, and this is true of all of those companies that we talked about that are already licensed everywhere. Arizona is kind of unique in that it's an origin state. Typically, it's wherever the order is received is where the tax goes to. The rest of the country, the standard is destination based. So it's where the order is being sent to that was where the tax goes. So as you can imagine, these national companies have national tax systems, and those national tax systems are set up to do things one way. So what we anticipate to happen, if it hasn't already happened, very soon you will see taxes coming from Amazon to your local community. I can tell you already that that is in fact happening. You are all getting taxes in your local community, from what your people tell me. So it will be, going forward, your location, it's wherever the buyer is located, will be what the tax rate is set at. Yes, back here.
What the Arizona League is proposing seems very reasonable. What opposition from the state should we be expecting?
She said what the league is proposing is very reasonable, and thank you. You're so correct. You are very insightful. And then the next question was, and what opposition from the state? And I'll throw the quotes on the state. Should we be expecting? I don't like to get out ahead of it if I can help it. I know that there are legislators in the room who I adore and respect greatly because they're so smart and so intelligent, and they're taking all of this and absorbing it fully. What we anticipate, if I were talking about me personally, what I anticipate is that something will happen. We still have Prop 108 that we have to deal with. There is still a way to look at this as being new money. You can also argue that it's not new money. It's sales that used to happen at retail stores, brick and mortar stores, are now happening online. All you're doing is recapturing what was local previously again. What the legislation will look like, I don't know. I can tell you what we would support. We support fairness. We support the same product being subject to tax no matter how you deliver it. We support economic presence as a concept. We support clear thresholds before liability kicks in. We support no retroactivity. We support having a retail tax base that the state and local level, anything that can be done by a remote seller, dealt with or delivered remotely, then that we agree that that should in fact be aligned with the state, and we are taking steps to do that. We'll have that in place more likely than not before the session starts. So, yes, sir.
So it won't be a big one off the state, but the local cities and towns have not been receiving that sales tax ever, and it's been going on for years, so it's not like, okay, it's going to replace sales that are already, that they're already going on. So we could, at the local level, see a bump, a pretty good bump in sales tax. It's going to be charged to the destination.
Right. So the point there was that whereas at a statewide level, and this really speaks mostly to Amazon, which again pulls down a lot of the ground what we're talking about here. At the state level, it should not really seem to make a big difference. I've seen widely varying estimates as to what the mix is between Amazon direct sales versus Amazon third-party sales, which would be sort of new money to the state. None of them are higher than 75% is Amazon original versus 25% third-party. So the third-party sellers through Amazon are the same small sellers that dot the rest of the internet on their own. So from a state's perspective, that's true. There probably won't be a significant change just by virtue of Amazon and what they do, or any of the other remaining unlicensed, non-collecting sellers. At the local level, you could conceivably see something of a move in retail, but you need to caution yourself. You've probably already seen it. Amazon already started reporting on a destination basis a little while before the decision actually came out. They started implementing local taxation. So when I speak to your tax folks out there, you are already seeing the Amazon direct sale revenue is probably already in your coffers. So that may not make a change. The third party piece is a wild card. I couldn't begin to estimate where that's going to be right now until I look at it more closely, get some better info. But that will be a piece of new money, absolutely. Mr. Laux.
Question number one, DOR issued a ruling that basically says, and has said Amazon is responsible and the taxpayer for all of those third parties. And then now that have they changed their position? And how are they going to reconcile that? Again, the picture in my mind are property management companies and,
Mm-hmm.
that we're seemingly headed in that direction.
Yeah.
And then after the answer to that, I'm curious about how Prop 106 when services.
Yes. Oh, Sean. Okay. You remember how when we were talking to him this last session, I said, Sean's really turned out to be a great guy all of a sudden? Yeah. I'm taking all that crap back. Let me tell you that right now, okay? So yes, the Department of Revenue does have a ruling out there from 2016 that said essentially that any of the marketplaces, such as Amazon, in particular Amazon, were required to collect on behalf of all of their third-party folks. Amazon didn't do it. But now they will. The Department of Revenue's position is that now, with the physical presence being pulled out, the Wayfair case supports 16-3 and makes it effective and the law. My concern is if we look too closely at it, then that's the way that legislation shows up because, I don't want to be subject to 16-3. I expect Amazon, that's why I said Amazon began reporting on a lot of those to all those other cities a lot earlier, but they were still not requiring their third-party people, even though they, by rule, had responsibility for it, but they weren't actually following it. The second question was, what will Prop 126, no tax on services in the Constitution, do to everything in the world? First of all, public policy, particularly tax policy by citizen initiative, is possibly the worst conceivable way of doing tax policy, and this is a perfect example of it. The language actually says that no tax or fee on any service that is not in place by, I believe it's 12/117 or 12/31/17, can be imposed or increased ever. Now, their commercial shows, pet care and health care and a variety of other things. If you go to their website, they talk about construction contracting. They talk about rent. They talk about things that we don't consider to be services, but we do very much consider to be taxable. And it doesn't define service anywhere. So I have no doubt that the thing is going to pass because it's too simple an idea and too popular an idea to say, whoa, those guys, they should never be able to raise taxes ever again. The problem is that we're going to be spending years and years and years in court defining what is a service and what is not a service, including things that we already tax right now. And where that will manifest itself, dealing with at the city level, at the local level, it doesn't happen much at the state level, but at the local level, you folks have a tendency to change your tax rate. And when you change your tax rate, you change your tax rate across the board, with the exception of residential rental or real property rental, because we got that, the realtors helped us again with that little piece in there that says you have to have an election. Well, now when you decide to raise your tax rate across the board because you need the money to pay for whatever, consider the fact that you can't raise taxes on contracting because apparently that could be a service, and you can't raise it on rental of property because real property because that could be a service, and you can't raise it on advertising because that could be a service. So you're limiting the number of places that you can actually do anything about your revenue stream. You're handcuffing the officials, and you're handcuffing not only at the local level but also at the legislative level. If you think Prop 108 is a problem, wait till you see the struggles over what is a service and what is not. Just look at digital goods. Digital goods assumes that software as a service is a service. Software as a service is just software rental. I'm just renting a program. There is nobody at Intuit who's doing my taxes for me. There's nobody at QuickBooks who's entering my receipts and my expenses for me. That's me doing that using their program, but because I'm renting it online and I don't download the whole thing, it's software as a service. Interesting story. Originally that was called software as a subscription, but then they decided that if you called it software as a service, it sounded less taxy. So there you go. So I'm not a fan of Prop 126, but I'm fearful that it absolutely will pass, and that will cause lots of fun for everybody, for attorneys anyway. Yes, sir. Actually, the more common method of a company like Amazon is to use there's a number of companies out there that create tax codes, tax rates based on geocode. So it will look at, it's keeping track of when you annex or de-annex a place. It does not go by zip code. Zip code is absolutely entirely unreliable in terms of what city or town something is. So there's a separate designation called a geocode, and the geocode is actually what things like Vertex and CCH and Avalara and all those folks use to determine. And with GPS mapping, and now we can pinpoint down to individual parcels. So, and it's all relatively inexpensive. Any other questions? Yes, sir. I assume that if you tax services, whether they're legal services or illegal services, they would be taxed. Is this a trick question about marijuana? Hold on. Okay, so let's go very quickly. Let's give an idea of what an actual service versus a product, a digital good might be. Everybody familiar with a company called LegalZoom? We've all seen those commercials, right, where you can get an attorney to talk to you through a little pop-up or what have you. What LegalZoom predominantly does, their main line of business is they sell fillable forms. So if you're on, like when I'm doing my third divorce, I don't need the help of the attorney. I'm just filling out my third set of divorce papers. I've done it before. I know exactly where to put stuff and where to hide everything. I'm good to go. So I'll just buy the blank form and fill it out and then trick my wife into signing it, and now she gets to live in Florida. No. But if I'm on my first one and I don't know what I'm doing, and I get confused about what it is that needs to be filled in someplace, I can either buy the form that I can fill out and print myself and do what I'm going to do, and I take care of all of the work. That's just selling a form. But if I need help with it, and I do want to engage one of their attorneys and get their attorney's advice, their attorney's help, there's a spot where I can click on it, and for $25 every 15 minutes or whatever it is, I can actually talk to an attorney. And that attorney will help me walk through it. So when I get done, I get down to the end of the bill, my blank form was $450, and then however many quarter hours of attorney time I used up, I get charged for that based on time and their hourly rate. So it's split into two pieces. It's split into the product that I bought, and it's split into the labor time that the legal advice was being provided. And they tax the form, and they don't tax the legal advice piece. Because the legal advice is actually professional service. It's not subject to tax in Arizona, not online, not in the office, not anywhere. But if I go to Office Max, and I buy a blank, fill it out Arizona divorce form, because I don't realize I can go to the county and get it for free. If I go in there and I buy it, I'm going to pay tax on that form that I bought. Because I'm just buying a piece of paper. I'm just buying a product at that point. If I go to an attorney, the attorney will write the whole thing up for me. I don't pay tax on any of it because they did all the work. I got to do all the work on the blank form. So that's sort of the difference that we have to balance between what is a service and what's not a service, particularly with regard to digital goods. Did that help? And in terms of legal and illegal, sales of heroin and meth and all those things, those are all tangible products. That's all taxable. There's no exemption. So, okay then. So moving on from prostitution, service, not taxable, online or off. There you go. Next. Yes, sir.
It would seem that changing from the location receivers, that the big warehouses, the cities, the big warehouses exist, you're actually shifting some of that local tax from them to the local cities, smaller towns. So I could see some resistance from the big cities to that change.
Sure. And this is one of those unique things about the state of Arizona. In the Model City Tax Code, there is already a priority set up of who gets the tax in terms of the local retail tax. And this applies specifically to retail. So if the sale happens in a store in your town, then that's the number one priority. It happened at the store. If it didn't happen at a store, in other words, it wasn't received in Arizona, but it was delivered from an Arizona warehouse, then wherever that warehouse is gets the priority and they get the tax. We also have a thing that we jokingly referred to as the Peoria rule, and then we saw it in the paper one year. The Peoria doctrine is I've got a salesman who lives in Peoria. He travels all around the state making sales. Who gets those sales? Well, your permanent location where you're receiving the orders is his house in Peoria. And then a couple of years later, we saw a thing in the paper that the cities determined where tax goes based on the Peoria doctrine, and I was like, this was an inside joke amongst tax auditors. How'd this ever get to the paper? But so hopefully that answers that. Yeah, it should still stay there. Yes, sir. Excellent question. Excellent question. The question was, how does this affect use tax on vehicles purchased from out of state when they're brought in? Right now, when you go to Texas, you buy a truck, you bring it back, you go to MVD, and you go to get your license plate, and you're going to pay use tax based on your garage address, wherever you would register that vehicle to. They collect both the state and the city use tax if there's one imposed. That's one of the things we're all going to be doing in the future, by the way. Please, please, please. How will this change that transaction? Well, that transaction's not going to change specifically because that's a buyer going out of state, buying something and bringing it home and getting it registered. So that's still going to be subjected to the use tax. Up until this decision, the Department of Revenue had two versions of Nexus. They had TPT Nexus, and then they had use tax Nexus. And this, in all likelihood, eliminated that differentiation, because the use tax nexus were just for people who were remote sellers. All the remote sellers had to deal with it. This essentially says that you can charge sales tax to those now remote sellers, so you no longer need to do a use tax for them. Let me caution you, the Department of Revenue still considers those to be use tax transactions at this moment in time. So unless something changes in that interpretation, which we hope, that they see it as a TPT transaction, a retail transaction instead of a use tax transaction. If it remains a use tax, then there is no county use tax in any of the counties, and they complain about that bitterly. There are a number of cities and towns that currently do not have a use tax either. So those cities or towns will not receive any of the benefit of the economy shifting more and more to these remote sellers. So that is why we will be encouraging all of you to impose a use tax to level the playing field for your local people who are subjected to the retail tax. Next question. Yes, ma'am.
Is it going to affect the prime contractors since they deal with products and services both? Are we going to have to start keeping track of what is product versus service?
Okay.
Like a 35% reduction overall?
Okay, let's take this. So the question was, will this affect contractors, prime contractors, because they deal with services and materials? And let's deal with people who are by definition, prime contractor. So we'll talk about new construction, which is the easiest way to do this. Right now, new construction in Arizona is taxed by the state based on construction cost, minus 35% for the standard labor deduct or standard contracting deduction. It effectively represents a negotiated amount for labor. That stays the same. Nothing changes. However, there are attorneys who work for contractors who, when Prop 126 passes, will come to talk to you about how that's a service and you can never increase the tax rate on contracting. So, to that extent, it will. Wayfair will have nothing to do with contracting. You can't sell somebody a new house over the internet. You can't build it in Wyoming in your kitchen and ship it via the internet to anybody yet, anyway. We'll wait for 3D printers and then see what happens with that. So, for right now, it just deals with retail and potentially some rentals. So, you're welcome. Next question. No? Anyone else? All right. Thank you very much. Please vote no on Prop 126. Not too bad. Oh, yeah. These slides are all online along with the Wayfair case, the full decision from the Wayfair case, including the dissenting opinion. The recommendations from the ad hoc joint task force is on there, along with one other thing that I can't remember off the top of my head. But it's really cool and you're going to like it. It'll be on the league website, yes.
Yes, thank you. Thank you. And so before everybody leaves, I want to thank you for coming. And I also want to thank Tom and Lee for their presentation and for all of their abundant knowledge and for making this as interesting as it could possibly be.